Okay, we're going to read the California Code of Civil Procedure. And we're going to start with part 2 since we did part 1 before. Part 2 is of civil actions. It's ranging between 307 and 1062. However, I guess that means there's a chapter 1 because I'm at chapter 2 right now. It starts at 315. So let's actually see if there's an intro. Chapter 1, commencing of the time of commencing civil actions. Let's see if we can read this aloud. Civil actions without exception can only be commenced within the periods prescribed in this title after the cause of action shall have accrued, unless where in special cases a different limitation is prescribed by statute. Section 315, the general procedure for the presentation of claims as a prerequisite to commencement of civil actions for money damages against the state of California, counties, cities and counties, districts, local authorities, and other political subdivisions of the state, and against the officers, employees, and servants thereof, is prescribed by Division 3.6, commencing with Section 810 of Title I of the Government Code. Okay, so we don't know anything about the timing yet, except that it's going to be in this section. So moving on to chapter 2, actually, let me see if the very beginning of this starts with 307. It really doesn't. So it says it starts with 307, but it starts with 312. So now we're at 315, chapter 2, the time of commencing actions for the recovery of real property. Hopefully we don't get stuck again. Okay. So this is adverse possession, incredibly antiquated real estate code or code of civil procedure regarding you need color of title though in this state. Isn't always the case. action shall not be commenced or entry or defense made after that period. $328.5. If a person entitled to commence an action for the recovery of real property or for the recovery of the possession thereof, or to make any entry or defense found on the title of real property, or no rents or services out of the property, is at the time the title first ascends or accrues imprisoned on a criminal charge or in execution upon conviction of a criminal offense for a term less than life, the time not exceeding 2 years during which imprisonment continues is not deemed any portion of the time in this chapter limited for the commencement of the action or the making of the entry or defense, but the action may be commenced or entry or defense made within the period of 5 years after imprisonment ceases or after the death of the person entitled who dies while in prison, but the action shall not be commenced or entry of defense made after the period. Okay. So part 2, chapter 1 defers to statute, defers timing of civil actions to statute, and otherwise applies. Chapter 2 deals with adverse possession. Crazy. I'm sure this comes up a lot, but we're at 329 and we only have 2 more sections. The time within which an action for the foreclosure of a lien securing an assessment against real property for street improvements, the proceedings for which are prescribed by legislation of any political unit other than the state may be commenced, shall be 2 years from and after the date on which the assessment or any bond secured thereby, or the last installment of the assessment or bond shall be due, or as to existing rights of action not heretofore barred, 1 year after the effective date hereof, whichever time is later. After that time, if the lien has not been otherwise removed, the lien ceases to exist, and the assessment is conclusively presumed to be paid. The official having charge of the records of the assessment shall mark it conclusively presumed paid if at the expiration of the time within which such action might be brought, he has received no written notice of the pendency of the action. Wow. Okay, and time lapse entitling lien satisfaction or excusing liens. Okay. 329.5. The validity of an assessment or supplemental assessment against real property for public improvements, the proceeding for which are prescribed by the legislative body of any chartered city, shall not be contested in any action or proceeding unless the action or proceeding is commenced within 30 days after the assessment is levied, or such longer period as the legislative body may provide. Any appeal from a final judgment of such an action or proceeding shall be perfected within 30 days after the entry of judgment. Last 330, in all cases in which there is now vested, or there shall be hereafter, hereafter be vested in a treasurer, street superintendent, or other public official the power to sell at public auction after demand upon him by the holder of any public improvement bond, any lot or parcel of land upon which exist or which shall there hereafter exist a lien to secure the payment of a public improvement assessment represented by said bond, and the act or law establishing such power fails to prescribe the time within which Such official may act. Said official may sell at any time prior to the expiration of 4 years after the due date of said bond or of the last installment thereof, or of the last principal coupon attached hereto, or prior to January 1, 1947, whichever is later, but not thereafter. This section is not entitled to extend, enlarge, or revive any power of sale which has heretofore been lost by reason of lapse of time or otherwise. All right, so let's move on to the next section, which is ought to be chapter 3, the timing commencing of actions other than for recovery of real property. All right, let's see how much of this can be read. It's about 2 years. Okay, so this is a really important section. So we're within 4 years now. So we had 2 years before, 6 years, 5 years. Okay, I just have to read this. Distracted. So other than real property, it's 2 years for like a tort, let's just say. 5 years is a tort, but it's like assault, battery, or injury in a wrongful act, not just like accidental. In 5 years, an action for mesne profits on real property, like basically like you earned parking fees on someone else's property who like didn't know that was happening. But mesne is more like cornfields, and you earned money on the cornfield. But anyway, an act for violation of a restriction under this Section 784 of the Civil Code. The period prescribed in this subdivision runs from the time the person seeking to enforce the restriction discovered or through the exercise of reasonable diligence should have discovered the violation of failure to commence an action for violation of a restriction within a period prescribed to commence an action. A restriction is abandoned, obsolete, or otherwise enforceable. So within 5 years, a violation of a restriction. Okay, so and since it's just after mesne of profits, I'm going to say this is like a violation of like an easement or whatever, a trespass on property, because a covenant, like a real covenant or a has been violated, and or a restricted covenant. So within 6 years, and I feel like it pertains to real property because what above it pertains to that. Now within 6 years, you're talking about like corporate bonds, notes, or debentures, and also in action upon a mortgage deed of trust or agreement pursuant to them, bonds, notes, and debentures. The section does not apply to bonds or other evidences of indebtedness of a public district or corporation. So, yeah, this isn't like a public bond, basically. It's only like corporate ones, or when California takes over the banking industry, they won't have this available at all within 6 years. But within 4 years, an action upon a contract. Important to know. Obligation or liability founded upon an instrument in writing except as provided that the time within which an action for a money judgment or balance due upon an obligation for the payment of which deed of trust or mortgage with the power of sale upon real estate or any interest therein was given as security following the exercise of the power of sale in such a deed or trust or mortgage may not extend beyond 3 months after the time of sale under such deed of trust or mortgage. An action to recover upon a book account, whether consisting of one or more entries upon account stated based upon the blah blah. So this was read, and you're talking about the amount stated. Fantastic. And I mean, we're in the area of a contract violation. It also wants to discuss like deeds of trust and mortgages, like as if that's not in the debenture section. Anyway, maybe individual or something. So we got around to an action based on the rescission of a contract in writing. And we had just entered into D under, I guess, 337 within 4 years, when the period in which an action must be commenced under this section has run, a person shall not bring suit or initiate an arbitration or other legal proceeding to collect the debt. The period in which any action may be commenced under this section shall only be extended pursuant to Section 360. And 337A, let's see if we can go back to our speaker. The term book account means a detailed statement of This is just a really long section, so I really don't think I can read it all. We get to within 3 years soon. But there's a lot of 337s here. So, wow, there's a lot of 337. 337A, right? The term book account means a detailed statement which constitutes the principal record of one or more transactions between the debtor and a creditor arising out of a contract or some fiduciary relation, and shows the debits and credits in connection therewith and against whom and in favor of whom entries are made, is entered in the regular course of business as conducted by such creditor or fiduciary, and is kept in a reasonably permanent form and manner, and is one in a bound book, or two on a sheet or sheets fastened in a book, or to backing but detachable therefrom, or three on a card or cards of a permanent character, or is kept in any other reasonably permanent form or manner. A book account does not include consumer debt. So make it to B under 337 in just 1 second. I just have to put something in the oven. I have to, but I want to. I get to. I don't have to, but I get to. More or less carnal. More. You get to. Okay. And for 25 to 35 minutes. 25 to 35 minutes. Commercial break. 337B, for purposes of this section, consumer debt means any obligation or alleged obligation incurred on or after July 1, 2024, and a consumer to pay money arising out of a transaction in which the money, property, insurance, or services that are the subject of the transaction are primarily for personal, family, or household purposes, and where the obligation to pay appears on the face of the note or a written contract. A, except as otherwise provided in this section, no action shall be brought to recover damages from any person performing or furnishing. So let's just review. Statute of limitations is like 2 years for, I'm going to say, criminal tort, and it's 4 years for like contracts and deeds of trust, and it's 6 years for no idea, and then it's fudge. Okay, that was actually the deeds and debentures. This is actually 6. 4, it looks like it has to do with like mortgages and consumer debt. If I had to break it like down into really broad terms. 337, we just define consumer debt. 337.1, A, except as otherwise provided in this section, no action shall be brought to recover damages or any person performing or furnishing the design, specification, surveying, planning, supervision, or observation of construction or construction of an improvement to real property more than 4 years after the substantial completion of such improvement for any of the following: patent deficiency in the design, specification, surveying, planning, supervision, and observation of construction or construction of. So 4 years has to do with construction as well. Okay. Injury to the real property or person arising out of such patent deficiency, and injury to the person with wrongful death out of any such patent deficiency. So I'm going to say patent deficiency. Now, B, if by any reason of such patent deficiency an injury to a person or property, blah. Okay. Just checking. May be brought within 1 year after the date on which such injury occurred, irrespective of the date of death, but in no event may such an action be brought before more than 5 years after substantial completion of construction of such improvement. C, nothing in the section shall be construed as extending the period prescribed by the laws of the state for the bringing of any action. D, the limitation prescribed by this section shall not be asserted by way of defense by any person in actual possession or the control as owner, tenant, or otherwise of such an improvement at the time any deficiency in such an improvement constitutes the proximate cause of the injury or death for which it is proposed to bring an action. E, as used in this section, patent deficiency means a deficiency which is apparent, Okay, by reasonable expectation. F, subdivisions A and B shall not apply to any owner-occupied single-unit residence. 337.15a, no action may be brought to recover damages for any person or the surety of a person who develops real property or performs furnishing of the design. We discussed all of that, specs, survey, plan, supervision, testing, observation, but the actual construction of improvement to real property for more than 10 years after the substantial completion for any of the following: a latent deficiency in all those things I discussed, injury to the property, real or personal, arising out of such latent deficiency. Okay, so if a awning of a store falls on someone within 10 years of, and nobody knows why, but within 10 years of construction. Okay. So that's for patent deficiency. 10 years for latent deficiency. In construction. I'm going to keep going, like maybe skip some of this. We're talking about how to find this out. Final inspection by a public agency, recordation of a valid notice of completion, the date of use or occupation of the improvement 1 year after termination or cessation of work on the improvement. The date of substantial completion shall relate specifically to the performance of those things I discussed: furnishing, design, specs, surveying, planning, supervision, testing, observation of construction or construction services. For each profession or trade rendering services to the improvement. That's your electrician, that's your plumber, that's your builder, that's whatever. Where a lease of real property is in writing, no action shall be brought under section 1951.2 of the Civil Code for more than 4 years after the breach. So 4 years has to do with a lease as well as your mortgage consumer debt. Does it say a lease of property? Real property. In whole or part, a lien not secured in whole or part by like a lien on real property issued by any county, city, county, municipal, corporation, district, including school districts or other political subdivisions of the state of California, and action upon a judgment or decree of any court or the real or the United States or any state within the United States. So if you're leasing from like the local park to have tennis courts for like a period of 30 years, and the park is a county, you have 4 years to bring your cause of action, notwithstanding the provisions of, I think, relating to the lease, but notwithstanding the provisions in section 337.5 of this code, actions may be brought on bonds or coupons as set forth in subsection 2 of said section, against which the statute of limitations ran on or after August 27th, 1937, provided such actions are brought on or before June 30th of 1959. Upon presentation for payment, they shall be registered and payment shall not be made thereon until the next fiscal year following presentation, unless available funds are sufficient to first pay obligations which are due or will become due from the same fund during the fiscal year of presentation and during the next succeeding 6 months. Interest shall not be paid on bonds or coupons registered for the purpose of this section. Within 3 years, an action upon a liability created by statute other than a penalty or forfeiture, an action for trespass upon or injury to real property. So this is 3 years now. We just skipped into 3 years, which is like a trespass. An action upon a liability created by statute other than penalty or forfeiture. Okay. An action for taking, detaining, or injuring goods or chattels, including action for specific recovery of personal property. And there's a 2 and a 3. The cause of action in case of theft, as described in Section 44 of the Penal Code, of an article of historical, interpretive, scientific, or artistic significance is not deemed to have accrued until the discovery of the whereabouts of the article by the aggrieved party, the aggrieved party's agent, or law enforcement agency that originally investigated the theft. Notwithstanding paragraphs 1 and 2, an action for the specific recovery of a work of fine art brought against a museum, gallery, auctioneer, or dealer in the case of an unwilling taking or theft, as described in the Penal Code of a work of art, 44 of that Penal Code of a work of art, including the taking or theft by means of fraud or duress, shall be commenced within 6 years of the actual discovery by the claimant or the claimant's agent, or both of the following. And in some cases, you need to continuously keep searching for this property. Like you learned that from Georgia O'Keeffe, I believe. You have to keep searching for the property if you're going to have like a forever statute of limitations based on when you find it. So now we're in the identity and the whereabouts of the work of fine art. In the case there is a possibility of misidentification of the object of fine art in question, the identity can be satisfied by the identification of facts sufficient to determine if the work of art is likely to be the work that was taken. Information or facts that are sufficient. This is like Romanet 2. To indicate that the claimant has a claim for possessory interest in the work of fine art that was unlawfully taken or stolen. B, the paragraph shall not apply to pending and future actions commenced on or before December 31, 2017, including actions dismissed based on the expiration of statute of limitations in effect prior to the date of enactment of the statute, and the judgment and the action that is not yet final, or a time for filing an appeal from a decision on that action has not expired, provided that the action concerned a work of art that was taken within 100 years prior to the date of enactment of the statute. For purposes of the paragraph, actual discovery does not include constructive knowledge of imputed by law, auctioneer, dealer, duress, fine art, museum, or gallery is all defined. Section 361 shall not apply to an action brought pursuant to paragraph 3. 5, a party in an action to which paragraph 3 applies may raise all equitable and legal affirmative defenses and doctrines, including, without limitation, latches or unclean hands. I would also say like being a bona fide buyer, but no. I mean, even if you sold the piece, even if it was stolen, then you sold the piece like 3 times, and now you're coming after the third buyer who bought it was a bona fide buyer. It doesn't say anything about that. So I'm going to assume that doesn't matter. Bona fide buyer would be here if it was anywhere. So an action upon a bond of a public official, except any cause of action based on fraud or embezzlement, is not deemed to have accrued until the discovery by the aggrieved party or the aggrieved party's agent of the facts constituting the cause of action upon the bond. So like it's probably not a bond, but maybe it's a bond. But for example, the Navy probably got a bond in order to clean up, like say for instance, like Hunters Point, Bayview Hunters Point, and they didn't. And this is saying, no, the cause of action in that case is not deemed to have accrued until the discovery by the aggrieved party of the facts, which is the public, of the facts constituting the fraud or mistake. No, I'm sorry, wrong section. An action upon a bond of a public official, except any cause of action based on fraud or embezzlement, is not deemed to have accrued, because fraud or embezzle will be longer, is not deemed to have accrued until the discovery by the aggrieved party or the aggrieved party's agent of the facts constituting the cause of action upon the bond. So let's just say they squandered the bond on totally other purposes and they didn't use it for its intended purpose. You have a cause of action once you know that, or it starts to toll once you know that. An action against a notary public on the notary public's bond or in the notary public's official capacity, except that cause of action based on malfeasance or misfeasance is not deemed to have accrued until discovery by the aggrieved party or the aggrieved party's agent of the facts constituting the cause of action. Notwithstanding F1 that I just read, an action based on malfeasance or misfeasance shall be commenced within 1 year from discovery by the aggrieved party or the aggrieved party's agent of the facts constituting the cause of action, or within 3 years of the performance of the notarial act giving rise to the action, whichever is later. We're still in 3 years, so I think so. A bond and let's say a public bond, I don't know, and a notary. An action for slander of title to real property is the next one. But we move right on to H. An action commenced under 17536 of the Business Professions Code. The cause of action in this case shall not be deemed to have accrued until the discovery by the aggrieved party, the Attorney General, the District Attorney, the County Counsel, or City Prosecutor, or the Attorney of the facts constituting grounds for commencing the action. I'm nowhere near the end of this. An action commenced under the Porter Cologne Water Quality Control Act. I'm just going to move on. J, an action to recover for physical damage to private property under Section 19 of Article 1 of the California Constitution. An action K, an action commenced under Division 26, commencing with Section 39000 of the Health and Safety Code. These causes of action shall not be deemed to have accrued until the discovery by the State Air Resources Board or a district as defined in blah Health and Safety Code, constituting grounds for commencing the action under its jurisdiction. L, an action commenced under Section 1602, 1615, or 5650.1 of the Fish and Game Code. I'm moving on. M, an action challenging the validity of a levy upon a parcel of a special tax levied by a local agency. Oh my God, on a per parcel basis. An action commencing under Section 51.7 of the Civil Code. I don't even know what that is. O, an action commenced under Section 4601 of the Public Resources Code if the underlying violation is of Section 4751 through 4621. I'm going to say generally it gives a couple of the Public Resources Code, blah, 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 conversion of timberland or to non-forestry related agricultural purposes. So this is all upon discovery. An action for civil penalties, and we go back to the Business and Professions Code. So I'm just gonna say business and professions. I'm gonna say health, environmental. This is all 3-year statute of limitations and forestry, fishing, game, whatever. Never know. 338.1, an action for civil penalties or punitive damages authorized under Chapter 6.5, commencing with Section 25100, Chapter 6.67, commencing with Section 25270. 17 minutes. commencing blah, 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 the Health and Safety Code, Chapter 1, Division 3 of Public Resources Code shall be commenced within 5 years after the discovery by the agency bringing action constituting grounds for commencing action. Okay? So 5 years, it didn't really preface that we went into 5 years, but I have no space for this. No, I do. 5 years for agencies is basically what I'm going to say for all these different health and safety and public resources. Okay. 339, within 2 years, an action upon the contract liability, obligation or liability not found on an instrument in writing, except as provided in section blah, blah, of blah, blah, section 337 of this code, or an action founded upon a contract, evidenced by a certificate or abstract or guarantee of title of real property, or by, I swear to God, that's why I did that, because I'm like bugging out. Real property or policy of title insurance, provided that the cause of action upon the contract, obligation, or liability evidenced by a certificate or abstract or guarantee of title of real property or property of title insurance shall not be deemed to have accrued until the discovery of the loss or damage suffered by the aggrieved party thereunder, and the action against the sheriff or coroner upon the liability incurred by the doing of an act of official capacity in the virtue of office or by the omission of an official duty, including the non-payment of money collected in the enforcement of a judgment. An action based on the rescission of a contract not in writing, the time begins to run. Upon the facts that entitle the aggrieved party to rescind occurred where the ground of rescission is fraud or mistake, the time does not begin to run until the discovery by the aggrieved party of the facts constituting the fraud or mistake. 339. So 2 years was 2 years was for criminal tort, deeds of trust. No, that's 6 years. So 2 years for a criminal tort and 2 years for contracts. What's the difference between this contract and the other contract? Has to do with real property, some official capacity of the sheriff or coroner, which is where a lease of real property is not in writing, no action shall be brought under section 1951.2 of the Civil Code more than 2 years after the breach of the lease of abandonment of the property, or more than 2 years after the termination of the right of the lessee to possession of the property, whichever is the earlier time. And within 1 year, in action upon the I'm going to say unlease. So now we got to 1 year. I got to rewrite this whole section. 1 year having to do with forfeiting, penalty or forfeiture. It doesn't really say what it's about. An action upon a statute for forfeiture or penalty to the people of this state. An action for libel, seduction, forged checks. A person who boards and feeds an animal, engages in veterinary medicine, and that person's neglect. Okay, so what's this? Libel, neglecting an animal, seduction, good faith improver for relief. The time begins to run from the date the good faith improver discovers the good faith improver is not the owner of the land upon which the improvements have been made. There's a lot in here about forfeiture, but it doesn't really say what is being forfeited. I assume it's a right. 340.1, A, there is no time limit for the commencement of any action for recovery of damage suffered as the result of childhood sexual assault. I'm just going to skip 1, 2, and 3. B, an action described in subdivision A, a person who is assaulted, again, cover up, recover, treble damages, cover up. Okay. C is defining what that is. D, the section shall not be construed as proof under evidence. Every plaintiff 40 years and older shall file certificates of merit, and certificates of merit setting forth the facts that support the declaration shall be executed by the attorney and the licensed healthcare professional. The attorney, 1 and 2, and the mental health practitioner is 2. And G, if certificates, in action subdivision E, the defendant shall not be served. And the duty to serve a defendant does not attach, blah, blah, the merits filed. Okay. I, J, K, L. We got into a demur and motion to strike for failure to provide certificates, and a DOE designation until there's been a showing or corroborative fact as to the charging allegations against the defendant, blah, blah, blah. Permission to amend. Corroborative facts is discussed if the application of the name a defendant is made before that defendant's appearance in the action, either the application of the certificate of corroboration, blah, blah, the name of the defendant. Okay. M, the court shall review a certificate of corroborating fact again, and the short keep under the seal. O, favorable conclusion of the litigation with respect to any defendant. The court may verify compliance with this section, execute a certificate to reveal the name, address, and number of person or persons consulted, relied upon with attorney preparation of certificate of merit, blah, 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 camera, judge in camera. And in the absence of the moving party, the court finds that there has been a failure to comply with the section. The court may, party's attorney or both, may pay a reasonable fee for, an attorney's fees for whom a certificate of merit should have been filed. P, the section is inclusive of things on or before December 31, 2023. No. Why does it say that? Okay. It's just saying that the statute of limitations before December 31st of 2023 is actually according to what was then in existence. Q, notwithstanding any other law, blah, 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 blah. And it cites a bunch of law. A claim for damages described in paragraphs 1 through 3, inclusive of subdivision A, is not required to be presented to any government entity prior to the commencement of the action. 340.11, notwithstanding. I really need this girl to talk. I really need you to talk to me, girlfriend. No. Notwithstanding. feel like this is repeating. This one has to be. So domestic violence is the next part. 3 years from the date the plaintiff discovers or reasonably should have discovered an injury or illness resulting from domestic violence. So suddenly domestic violence is 3 years. Like we just keep flying around. There's like unlimited years. Unlimited years for sexual assault after, I don't know, December what again? December who again? Um, Dude, I don't even know. But then we started talking about domestic violence, and that's 3 years. So add domestic violence. And skip on to recovery of damage as a result of sexual assault, 18th birthday, 10 years from the day of the last attempted act, 3 years from when it reasonably should have been discovered illness, injury, or illness resulted from the act. As used, sexual assault defined, criminal prosecution, result of sexual assault, ring bought, resulted in a conviction or adjudication. The subdivision does not limit availability of cases and action permitted under Section A, including cases of action against persons or entities other than the alleged person who committed the crime. 3 is giving you some statute of limitation details. Such claims are hereby revived and may be commenced until December 13th of 2016 for an act on or after January 1, 2009, and is commenced on or after January 1 of 2019. That would have been barred. Okay, it's been expanded until 2026. A claim that has been litigated to finality in a court of competent jurisdiction before January 1 of 2023, and a claim that has been compromised by a written settlement agreement between the parties entered into before January 1, 2023. So those are things that can't be revived. Now, notwithstanding any other law, claim, or recover more than $250,000 in damages arising out of sexual assault. Code. Dang. Code. We skipped some stuff. Okay, so we skipped. Seems to like after disability from asbestos. I gotta write these down. I think this is very. I read that case. All of these were made by case law. Looking at it because there's ants everywhere. Against there's a ton of time frames for this. I'm just gonna say 4th grader for I can't believe it. What's that? Yeah. Years. Okay. This is- Oh my gosh. Okay. We're getting there. We're almost there. We're gonna get to the end of this. my God. Really? Oh my God. Ugh. Okay. I have to leave for tennis. So I'm going to quickly wrap us up. I was going to do a review. I'll do a review in the next session of what I've written down is 10, 90 days, blah, blah. So 100 days. Okay. So I guess it's 4 years for bonds and coupons from the state. Because we were kind of in the 4 year section and it doesn't say, oh, there's no limitation. Okay. So that has to go down there too, to no limitation. All right. So within 180 days, I like have nowhere to even write this. I'll write it up here. 180 days, underground trespass, occupancy, well, okay. Wells, underground trespass. And conversion for moving that, even though we talked about Mesney. Continuing character of such an act, there should be but one cause of action for such act. Okay. Shall accrue as aforesaid in all. Talking about petroleum, oil, and gas, natural gas, and limitations prescribed in this section do not apply to actions or actions to be brought in the name or the benefit of the people, the state, etc. So this would be private action. Because I don't know what public action is. Okay, it's just inapplicable. So 349.1 and 349.2 and 349.4 are the last 3 sections. The validity of any acts or proceedings under the color of law for the formation, organization, incorporation, dissolution, consolidation, change of organization, blah, blah, or for any change in the territorial boundaries of a city, county, city or county, special district, public corporation, or public entity, or improvement district within a newly formed shall not be contested in action unless such action shall have been brought within 6 months from the date of completion of said acts or proceedings, unless an action is commenced within said period, and all acts or proceedings in the same valid. I think I wrote that down already. Maybe not. Yeah, I wrote invalidated dissolution of corporation, or formation, of plus public entity, etc. District. So that's a plus. Okay. That was 6 months. Where any proceeding or under the color of law, the validity of such acts in the proceeding for the authorization of bonds shall not be contested in any action unless the action shall have been brought within 6 months. So 6 months again. I think I already wrote this. Okay, so bonds. What about bonds? Sale, issuance, authorization. And these are actually public bonds. All right. talks a little bit about what we're talking about when we say validity of sale, validity of issuance or delivery of, unless the action is commenced within the time above specified, shall be held valid in every respect and incontestable. No section shall mean to repeal this section for a shorter, prescribing a shorter period than that therein. And bond, what's the definition of bonds? Last section, all the acts proceedings here too are hereinafter taken out of the color of law, organization, or corporation of a change of territorial boundaries, and we already said that. Annexed area or zone within any of the foregoing, and for the authorization, issuance, sale, or exchange of bonds for the territory, a legislative body or entity may instruct his court or secretary to mail a notice to the nearby owners, as known, for the zone or improvement. Okay, we're talking 60 days. Well, we need to notice in 60 days. Mailing of said notice. File an action contesting the validity of all that stuff within 60 days. Okay. 60 days. Do I have that written here? 60 days after 60 days notice of I'm going to say neighborhood improvement. Okay. By like public entity, right? For the most part, might have said corporation, organization, and corporation of. So apparently, I don't know. So that's going to be it for chapter. I have chapter 3. Yeah, the time commencing actions other than for real property. So we're going to leave it at that for this minute.